Honorable Justice Subramaniam Prasad, Judge of Delhi High Court, and associated at the chamber of Mr. Atmaram N.S. Nadkarni, former Additional Solicitor General of India and former Advocate General of Goa. Mr. Nileshwar practices in various areas of law such as constitutional law, income tax act, environment law, service and labor law, law of crimes, and many more. Now, if I further talk regarding his publication, he published a research paper on rights of child. He also co-authored a research article and the emergent need for a legislation and a paper on the religious right of communities called the nationality equality in Article 14 of Constitution of India to the Women's Journal of Legal Studies. He attended the summer school program also at the London School of Economics in 2018, and the topic opted International Human Rights Theory and Practice. He co-edited the book Parmeshwara to PP, which is published by Mohan Law House in September 2019. Co-authored a research article on genocide related to displacement, which was selected for publication in a book being compiled by Mr. Chandar Prakash Singh, practicing advocate of Jammu and Kashmir High Court. Mr. Nileshwar also authored articles titled Remarkable Judgment that reclaims human rights by use of CCTV in interrogation, published by the leaflet, and also authored an article titled Structuring the Unstructured Jigsaw on the Data Protection Bill 2018, published by Update Magazine in the January 2021 edition. And at last, authored articles titled Do Laws Suffice a Psychotropic Paradise and also Decoding the Code on Wages 2019. Now, I would like to hand over the mic to Mr. Nileshwar, sir, to start the webinar.
Thank you so much, everyone who has come here on a Saturday afternoon so early. And I want this to be an interactive session, and please feel free to ask any questions at any given point of time. Just allow me to complete my sentence, and then you can pop in. And so today's topic is the right to privacy. I would like to ask you all, what does privacy mean to you? Personally, what does it mean? Anyone, you answer. Shrishti, what does it mean to you? What does privacy mean to you? You're a second year law student. You're grappling with the concepts of law and you're learning law. You must have learned a little bit of CPC, a little CRPC, whatever, IPC. What is privacy to you?
Sir, privacy is something related to our personal life.
Right. Absolutely. So I would like to start with talking about privacy and privacy in personal life, right? You said personal life. Personal life means intimate relationships also. Privacy in intimate relationships. What you have all read the Indian Penal Code and Section 377, which criminalizes homosexuality. Two adults, consenting adults sleeping with each other was a punishable offense, punishable with life imprisonment or 10 years of imprisonment. Wasn't that an incursion of the state to regulate human behavior? How can a state ascertain whether what you're doing in your confines? How can it be proved? How can such an offense be proved? That is why the Supreme Court struck it down in Navteej Singh Johar and said that, listen, all this is not at all acceptable, because privacy is an inalienable human right, and it is deeply connected to human dignity. Privacy emanates out of human dignity, and please understand this: privacy is not a constitutional right. Privacy transcends the constitution. It precedes the constitution. It has been there before the constitution, is what the five learned judges of the Supreme Court and Navteej Johar said. That dignity is the essential component of human life. And these are natural rights. The right to privacy is a natural right, and it cannot a stat a provision on a statute book cannot dictate your conduct with another consenting adult in a private room. That's what it said. And what this judgment also lays down is fundamental propositions of reversing Victorian morality that many of our laws even now follow. Relics of the past, our colonial history. IPC, after all, was made by the Britishers, yeah, to govern us until we became independent, started governing ourselves. We adopted the IPC. Now, provision like 377 in the modern day and age with technology all around, and at a click of a button, you're in US, at a click of a button, you're in the UK, at a click of a button, you can teleport yourself anywhere with this wonderful technology. This wonderful technology has enabled me to come to your college on the net, on the internet.
ముఖ్యంగా అందివచ్చిన ఈ అవకాశాన్ని వినియోగించుకోవడంలో రాష్ట్రపతి ముఖ్యమంత్రి జగన్మోహన్ రెడ్డి కానీ పూర్తి స్థాయిలో సఫలీకృతం చాలా స్పష్టంగా చెప్పాల్సిన అంశం. ఎందుకంటే ఆయన చాలా
I'm sorry, there's some disturbance.
ఆయన
I can't, sorry, I can't hear you. Yeah, thank you. So it is, after all, we are adopting modern values of liberty. We are adopting modern values of equality. And equality. So let me trace this right of privacy back. The right of privacy, the first time someone said the word privacy and asserted that there is such a right of privacy was in an essay by Louis J. Brandeis and Samuel H. Warren in the United States Harvard Law Review of 1890. That's the first time someone advanced an argument that such a right exists. A right to privacy exists, and argued that against state instrumentalities, against the excesses of state, against the oppressive mechanisms that state takes, that a right to privacy does exist. And of course, you would know that Louis Brandeis went on to become an associate justice of the United States Supreme Court. Now, over how long has it been? 135 years since 1890, since the right to privacy was first thought of, first envisioned. This law, this right has inured. It has become stronger. It has, through time, it has matured up, it has developed. And now it's come to a point where a 9-judge bench of the Supreme Court, and mind you, a 9-judge bench is a huge number of judges, a large number of judges, say that privacy is an inalienable human right and it's a natural right, obviously subject to reasonable restrictions of law and order, of peace, tranquility, of social justice, in a sense, of other important things, of contempt of court, of all those reasonable restrictions that you have in 19.2, that is freedom of speech. 19.1.2, you have reasonable restrictions on the freedom of speech. Similar restrictions are placed on the right to privacy. A right to privacy is not an absolute right. If you think it's an absolute right, then it's not. Now we come to the definition of privacy, which I would like to read to you. And allow me this, that I may read this definition to you of the right to privacy. And please listen to this, because every word here is solid gold and it carries so much meaning, even though this was written over 80 years ago by Breckenridge, who wrote a book on the right to privacy, not 80 years, 60 years ago. He defines the term privacy as, and I quote, the rightful claim of an individual to determine the extent to which he wishes to share himself with others and his control over time, place, and circumstances to communicate with others. It means the right to withdraw or to participate as he sees fit. It also means the individual's right to control dissemination of information about himself. It is his own personal possession. Now, this is what A.C. Breckenridge defines privacy as so pertinent that it is very individual specific. It is not. It is. It is also a right against the state. Now, let me take an unpopular example and tell you with what happened with a journalist, a very famous journalist who comes on TV and yells and shouts, which is his right to speech. I mean, that's his right. He can yell and shout so long as he doesn't incite communal violence, etc., and he is within the social order of human communication. When the Mumbai police went to his house to investigate into a case that was 3 years old and there was no investigation done in it, no trial happened, nothing happened. 3 years passed, 3 years, 3 years old case of abetment to suicide. They barge into his house, they thrash him left, right, and center. Some people might think that that thrashing was justified, but purely legally speaking, it was an invasion of his privacy. It was an invasion of his privacy. He could have been given a notice to appear before the police station, which he would have. Similarly, if you see other examples, can you now say, so my point being that privacy is also a right to protect the individual from the excesses of state authorities and instrumentalities. Can you say now that I'm not going to disclose my income tax returns because it's my private income? I have earned it. It's my right to privacy to keep it for my family and for my future generations. Is it possible? No, because there is a law on income tax that you have to pay income tax if you qualify a certain level of income. If you earn a certain level of income, you have to pay income tax on it. There's no choice in it. It subserves the larger public good. It is the money because of which development happens in the way it happens. Can you say, now take this classic example of marital rape, which the Delhi High Court gave a split opinion upon. It's not even a verdict because a verdict is unanimous, or at least has a majority point. Here there were two judges who differed and one agreed, one disagreed. Can marital rape be enforced? How? How does a woman prove marital rape in a court of law? Is forget the proof. You tell me that whether wouldn't it be an infringement of the husband's privacy? That what is happening in the confines of a room, that a policeman comes with a DNA lab testing kit into his room and checks for samples of force on the bed or the cot or whatever. Isn't it an infringement of his privacy? Something he does with his wife. The morality of it may be questioned. It is questionable. And there's no decision that the High Court has rendered at this point. It's just an opinion. So the issue of marital rape is up in the air. Uh, how can it be proved? It can't be. If a wife is aggrieved, she can probably file for cruelty. It discovers cruelty. But anyway, what I'm saying is it violates privacy. Now, now, We have the right of free speech, we have the right to life, and the Supreme Court in K.S. Puttaswamy, the ninth judge bench, which I referred to earlier, says that privacy is an inalienable right, privacy is fundamental, subject to restrictions, but it also says, it also expands on the right to information. How do you, this is the real question. How does one balance the right to information that subserves the common public good with the right to individual privacy? These are two heads, and they are in the opposing directions. They are conflicting. How does one balance that? Information now, the Right to Information Act, it's a beautiful legislation which is enforcing political, social, and economic transparency in public offices. When you say that, okay, let me give you an example. If tomorrow, uh, there are many lawyers who are politicians and who become ministers as governments come and go. So, say a lawyer has had a very good practice, has a private practice. I don't want to take any names, and that person's become a minister. And then again, when the government he represents is out of power, he's back to law. Can somebody file an RTI for the disclosure of his wealth? Can he? Can any person do that? To disclose your wealth? Tell me how much you have in your bank. That's his privacy. He can protect it. He can assert it. He can assert that right. Does it happen? Can it happen? To answer this question, it is simple. It's a very thin line of, as many Supreme Court judges say, judgments, sorry, say on free speech, it's very thin line of balancing competing interests. So you can say that privacy is breached and you can refuse that information when the person whose whose information is sought after is not in power. See, because you can say Mr. X is law minister during 2014 to 2019. He is no more the law minister now. Every information that is sought under the RTI between 2014 to 2019 is valid and has to be given to the information applicant because he was at that time performing a public duty. He was in a high office. He was representing a mass of people for whom he was making legislation, for whom he was shaping policies. But after 2019, he is not in that official position. When he's not in that official position and is resumed some other occupation of him or her, he can't be compelled to disclose bank account details. Let's take another example. Movie stars, film stars, Bollywood actors, do they have private lives? Are they entitled to equal privacy? My answer would be no, because they put themselves out in the public domain. They have lesser privacy than others. They have a lesser amount of individual freedom and privacy compared to, say, you or me, because we are nobodies. Nobody recognizes us, whereas they are all over the place. Everybody knows them, everyone recognizes them, everyone knows their names, everybody knows their houses. Most of them know what I mean, most of them have a mass following. All of them have a mass following. So people are intrigued by the personalities and people want to know what goes on in their life. They also have privacy, but the degree of privacy is much less, and it cannot be equal to the privacy that you and I enjoy. What can a film star do if some cameraman, goes climbs up a tree and tries to sneak into their house to see what is happening in a party that person has hosted? What can they do? Can they cut the branch off? That person will be prosecuted for culpable homicide, or or even or even grievous hurt. I'm just trying to explain this concept of privacy in multiple layers so that you guys understand what privacy actually is. And I would urge you all to read Brandeis and Samuel Warren's treatise on privacy of 1890, that Harvard Law Review, which I just spoke about some time back. uh, Now, let's come to a little more legal aspects of privacy. What rights do you have against the state to protect your privacy? When an income tax official comes to raid your house, can you say it's a violation of your privacy? It's definitely arguable, but can you say you have a right to privacy? You are doing something illegal and you're concealing it, and then you put up the excuse of privacy. Well, largely it depends on a case to case basis. As lawyers, we work on case to case basis and nothing is cast in stone. But the manner in which an investigation is conducted, I do believe, after the Puttaswamy judgment, which overrides a numerous host of constitution bench judgments, there should be safeguards to privacy, because a bench of 9 judges has said this. Our statute books, especially the ones which give wholesale investigative powers to agencies, they need to examine and look into this aspect of respecting privacy and not totally breaching it. Of course, there are occasions where you can't respect privacy, and the public interest requires you to do so. In those cases, it's justified. But in most common cases where small people are involved, smaller people are involved, less influential, less powerful people are involved, uh, they should respect the grain and text of the Supreme Court judgment, and they should accordingly modulate and tweak their memorandum of procedures or their internal rules regarding investigations, how to conduct it, how to raid, how to give notices, how to seize a place. Of course, this applies only to revenue offenses and say income tax, FERA, FEMA, your ED, CBI. It doesn't apply to say theft or murder, dacoity. Can't apply to that, because there you have to nab the person, because you can't say that if a person is murdered, that the right of privacy of another person is greater than the life of a person. That has to be maintained. That's something we should look into. I just wanted to ask Pavan or whoever is here, how long can I go on for? I'm sorry, I can't hear you. You're not audible.
Sir, it's your discretion. Actually, the webinar has been scheduled for 1 hour, but we are happy. We'll be happy and we are lucky also if you continue for more time.
No, no, it's fine. I'll stick to time so that I have you guys would be having a lot of questions. I hope you have questions because I'm ready to answer them. But I will stick to my time.
Yes, sir. Sir, sir, one question. According to now, like the present scenario, what is the actual meaning of privacy according to the Supreme Court?
That's a very interesting question. and I would read out. I want to read this out because I had, when I was just reading up to, because it's so daunting a task to address young minds. I wanted to say what privacy means according to the Supreme Court, and I'll read it out to you now. Just, just give me a second. According to the Supreme Court, and this is very important, I feel, very important in the judgment, you find it at para 479 of Justice Nariman's judgment. This is this that privacy is not a vague concept. And I quote now, the argument that the right to privacy is so vague and amorphous a concept that it cannot be held to be a fundamental right has no force. Mere absence of a definition which would encompass the many contours of right to privacy need not deter the court from recognizing privacy interests. These interests are broadly classified into interests pertaining to the physical realm and interests pertaining to the mind. This concept has traveled far from the mere right to be let alone to to be let alone, that concept of which Brandeis and Warren propounded, that this concept has traveled far from being a mere right to be let alone to recognition of a large number of privacy interests, which apart from privacy of one's home and protection from unreasonable searches and seizures, have been extending have been extended to protecting an individual's interest in making vital personal choices, such as the right to abort a fetus, right of same-sex couples, including the rights to marry, rights to procreation, rights to contraception, general family relationships, child rearing, education, data protection, etc. So, this is what the horizon of privacy means, according to the Supreme Court, and it's beautifully put in the most succinct manner that is that can be done, and it is actually just remarkable how well the Supreme Court, through Justice Nariman here in this the part I quoted, has put it. He's a real genius. And the Supreme Court in this judgment also says that, you see, privacy is not a derivative right. What is a derivative right? A derivative right is something that you interpret into it. The court interprets it. It's not expressly given anywhere. Court will interpret it on a case-to-case basis. Derivative rights are, now, the right to life. What is right to life? 21. Correct? Now, in 21, in the 1970s, the Supreme Court expanded this right to life, which includes right to education, right to healthcare, right to affordable healthcare, right to clean drinking water, right to education, right to uh, right to be granted a equal pension, the right to the right to the right to freely do whatever they want, the right to air views, no matter how uh, difficult it would be for others to listen, because some views are not palatable, but they still have a right to be aired and to be spoken, no matter if you don't like it. the right of under trials, the rights of under trial prisoners. Most of them, some of them, large portion of them are in jail because they are targeted people. They are decoys. Supreme Court saw it and said, right, under trials also have rights. Justice Krishna Iyer and Justice Bhagwati said this in Charles Shobraj and Sunil Batra 40 years ago. And they gave these derivative rights. This is a derivative right. And now I want to come up to another concept, which is a more concerning cause for everybody. And it should be for you young people also, because see, now we are on the internet. We interact on the internet. We shop on the internet. We uh, we do all sorts of things on the internet, and it's made us it's made the world a smaller place, and it has made it accessible. But there's a grave danger that our data is being stored, collected and stored to not for purposes that we expressly give our consent for. Our data is being shared with companies, with corporations, with entities that use our data to for all sorts of purposes. Even if that even if they're not doing anything dangerous with the data, there is a potential that they have stored our data and their systems have it. And it may pose a threat. Who knows? It can pose 1,000 threats, and I can give you examples of how it can pose threats. I would really urge you all to watch this movie called Snowden, based on the life of Edward Snowden, who was a hacker, and he exposed the privacy infractions, the digital privacy infractions that went on in governments. The entire scam of Cambridge Analytica. You guys must read up on it, along with Brandeis and Warren's paper on privacy, to put everything into perspective. Now, when I say, let's take the example now of Aadhaar. What is Aadhaar? Aadhaar card, your Aadhaar identification number. What is UADAI? What is all this? What is the great excitement about all this? Aadhaar was a project conceptualized to unify the country in one way, to have unified systems of identification, where you identify all the people in the country. See, we are a diverse country. There are tribals, there are people who are cut out from reality, from human society, from civilization. They still live in very small and remote places where civilization is a far cry. They don't know, they are used to systems, ancient systems. And our country, don't doubt it at all. There are countries as vast as you can think. And it's a melting pot of all cultures, etc. But it's also a melting pot of all diversities. There are a lot of people who are away from reality. So this project was conceptualized basically to unify them, to bring them into the system, to bring them under the radar or under basically the census or whatever, and have an additional ID proof by assigning them a number, a 12-digit number. And what does that legislation do? It very cleverly reads the directive principles of state policy, which is an obligation on the state to make laws that benefit people. uh, they made some directive principles of state policy, such as everyone should be having adequate health care, everyone should receive food, everyone should be able to, uh, you know, everyone should develop a scientific temper, etc. People, and policies that are made by the executive should be in a way to, diffuse. To diffuse the concentration of wealth in a few hands. Now, the government says in the legislation that we are going to link Aadhaar to the social benefits you get. So the parchun ki dukan you go to for your groceries, poor people who go to subsidized ration shops, they are they were it was made mandatory to have an Aadhaar card for a ration shop to be able to fill your stomach, because you're poor and you can't go to a fancy grocery store. You have to produce an Aadhaar card, otherwise you won't get your ration at subsidized rate. And it was envisaged basically to see, you know, you linking benefits like food, linking benefits like healthcare. Now you've linked banks with Aadhaar. The Finance Act of, I think, 2017 or 16, that says, uh, I think it's section 139 double A of the Income Tax Act. I think so. You have to check. That says that Aadhaar and PAN card should be linked. The 9-digit or 10-digit PAN card number should be linked with your 12-digit Aadhaar card number, and that should be stored with every bank you have an account in. What does it do? What is the impact of all this? You're linking election card, your voter ID card, with the Aadhaar card. If you are going to a hotel to stay, say any of you guys, you're youngsters, you go with your friends, you go to a hotel, it's your privacy. You They will ask you for an ID. And some I've seen this, that some places they insist on an Aadhaar card. I say, this is my driver's license, take it. But they would insist on an Aadhaar card. What does this do? Every spot where you gather this information and you're giving out this information, on some system somewhere, the government knows your location. Would you want the government to know your location, where you're going? You're a happy citizen, you're not doing anything illegal, you're law students, budding lawyers, leaders of tomorrow. Do you want the government to know everything? Of course not. You want to protect your privacy. You'll be like, why should the government know I'm not a dreaded criminal? I'm not some anti-social element. Why should they then know about my whereabouts, whatever I'm doing? That is the fundamental problem with Aadhaar. Not only that, the 12-digit number is nothing. They take your fingerprints and your iris scans. Now they are unique to you. As you know, your fingerprints are only one of a kind. Your iris scan is unique to you. There are very few identification marks on your human body that are unique to you, that only you have, and that can distinguish you from someone else. It's like your DNA. So this is the problem with Aadhaar, and I feel, it's my personal opinion. Don't take it for anything, but it's my personal opinion that if you're making poor people show their Aadhaar cards instead of their ration cards at a ration shop, it's almost criminal, because they don't care about their privacy. They care about the next meal. However, that's my personal opinion. Don't pay any heed to that.
Sir, to
Uh,
know whether a person is a criminal or or a sane person.
Sorry,
To know whether the criminal, to know whether the person is a criminal or not a criminal, they need information.
I'm sorry, ma'am. Your voice is breaking. I can't hear you.
Is it clear, sir? Sir, is it clear now?
Why don't you do something? Why don't you write your question down to the host, and the host will read it out later to me.
Huh.
Now, now the second thing is that uh, with Aadhaar, the problem is that you already have a host of identification proofs. Why do you need this unifying identification proof? You have election card, you have ration card, you have uh, driver's license, you have your PAN card, you have your school identity proofs, you have your college identity proofs. If you are a doctor, you have your medical authority license card, you have the card of your hospital. If you're a lawyer, we have a proximity card in the Supreme Court. We have the Bar Council's card. Any profession, you have cards. If you're a jeweler, you have those ag marks and those certifications of valuation, etc., that show your bona fides. If you're a company, you have the registrar of company ka certificate on their letterhead, which shows that your company. Why do you need this? There's obviously, I mean, something is amiss. To my mind, there feels when all these mechanisms are there in place, why don't you utilize them or upgrade them, update them better, then have this mechanism, which is more sinister than it meets the eye. So that's why I am in complete agreement with the dissenting judgment of our present Chief Justice, Dr. Justice D.Y. Chandrachud, who said that the Aadhaar Act is unconstitutional. And I will request you all, it's a very long judgment, but do try and read it. Puttoswamy, I think 2016 or 17. Now, coming to now the next concept and the last concept that I have to talk to you about. It is the data protection regime that we need today in the country. We have a data protection bill of 2019 that was tabled in Parliament, referred to a joint committee, now has lapsed again, now is being reintroduced in Parliament. That data protection bill of 2019 was based on the B and Shri Krishna committee report that the government appointed to sort of develop a law to protect data of people that we freely exchange over the internet. Now, you see this certificate of practice of mine. Any one of you can take a screenshot of this and zoom in with a high definition camera, can take the screenshot of this and take my certificate, do whatever you like with it. You guys can probably get an internship tomorrow, saying that I know this person, I clicked his photo from there, I met him here, and he has recommended me. I mean, I'm just saying that these are threats to an individual's privacy also. So, this data protection bill is basically nothing. It is to say that it classifies your data into certain segments: sensitive data, core sensitive data, public data, private data. What it means is this, like, I'm sorry, just one. Sorry. So it basically classifies data into personal data, sensitive personal data, and critical personal data. What are these data? Your iris scans, your biometrics, your fingerprint, your thumb impressions, your leg impressions, your feet impressions, your medical condition, your a birthmark on your body that only you have and nobody else does. The information in your bank, your financial information, your health information. You're suffering from a terminal disease. You don't want the world to know, but somehow they know. Somehow someone gets to know. It would mean that your medical records have been tampered with, either by the hospital or by somebody in your house, or someone who has access to your house. Your educational information, your job information, where you work, how you work, your critical appraisals, they're all your data. And what this data protection bill seeks to do is to classify data in order to provide a regime to protect it against the state and against other individuals also, private individuals. Now, everything's stored on the internet. Now, someone will take a photo of this webinar and put it up on the internet. When I type my own name, this photo will come up. How does it happen? Because the internet, with the developing, growing technology, has facial identifiers. It can identify a face and see whether on the internet there is an existing face like this. Is it already there on your Facebook, on your Instagram, on your WhatsApp, on your LinkedIn, on your Twitter, on your whatever, Viber, Signal, anything, Tinder? What do you do? I have not consented that you take my picture and upload it, but it's anyway there. Can I do something about it? Can I? I don't think I can. But let's look at this. Okay. What is your name? Shrishti. Now, say Shrishti is being prosecuted for a crime which she has not committed. All newspapers are now, after Shrishti, Shrishti is a bad person and she's done this and that, and. But Shrishti has not done it. She gets vilified for nothing, and tomorrow a court acquits her. Now, when a court has acquitted her, does the impression of Shrishti that was propagated through the media or propagated through newspapers or channels, television channels, or social media, can her reputation be restored? Can it be?
Sir,
No, it can't. But the data protection bill has a clause of the right to be forgotten. When someone has been wrongly prosecuted, when someone is wrongly targeted, when someone is exonerated from a court of law, when someone is declared innocent by a court, when some investigation finds out that this person has no complicity and what was said only based on surmises and conjectures and guesswork, that's when a person has the right of that information that was disseminated into the public domain to be forgotten. That's what our law is, and that is what we seek to build a more digitally comprehensive structure of laws that protect us on the internet more than outside in the outside world. We are more unsafe here. Someone can take a photograph of me and project me in a in whatever clothes, in funny clothes, morphed pictures, morphed pornography. Anything can be done, and we need to be protected against it. We need to guard ourselves. And the best way to do that is to educate ourselves against contemporary ideas, of contemporary ideas. And I think I've exceeded my time limit a little, and I think I would now take questions. Thank you very much for listening to me.
Sir, a small, it's not like argument, but a small thing. Isn't there are many scenarios or many situations where Supreme Court ordered the social media platforms to remove the statements or the things that they made against the victims or the accused
Yes,
as
yes, yes. You're right. They have done it. But the internet is such a place that once something is there on the internet, it's very difficult to raise it. Even when the entire law machinery goes into an accelerated motion to erase it. But it's very difficult in practicality. It's very difficult. You're right. You're absolutely right. You're talking about Mr. Azam Khan who made remarks about that the girl.
only as a concern, but there are many situations. Recently, an incident in which took in a law university where a girl was being victim in a case. And there are
I
case,
think
there are
the Delhi High Court has taken cognizance on that and directed the charge sheet to be filed within 4 weeks, for 6 weeks, if I'm not mistaken. That's what you're referring to, right?
yes, sir. So, sir, another question is that isn't right to privacy really a challenging thing for the Supreme Court to maintain in the cases?
Yeah, it is.
And
It can.
even for corporate field,
Hmm?
right to privacy, maintenance of right to privacy or protection of right to privacy is challenging even for the corporate field, no, sir?
That's true. It is. See, corporations are not bound by privacy at all. They can do as they like. Unfortunately, they'll give you a package of 2 lakh rupees a month. They'll make you sign non-disclosure agreements, which will have all the clauses of the world, and they will say even I don't want to say anything because it's a public platform, but they have the most absurd things in these non-disclosure agreements. In the name of these non-disclosure agreements, I just happened to see a Bollywood agreement. Basically, I mean, someone from the industry, some actor, uh, I happened to go through their agreement. It's so one-sided, it's so lopsided, and their privacy is thrashed. You think they have privacy? There's no such thing. It's only against the state can you claim some privacy. That too, if the court is in your favor and you are in the right. The court agrees to be convinced to your favor.
So will this right to privacy even be applicable for the courts as well?
Of course, the right to be forgotten. But I doubt, because higher courts are courts of record. They have to maintain record of every case. So that, but it can't be disseminated further. There can be stoppage orders, there can be gag orders by the court itself to protect the right of privacy.
Okay, thank you, sir. So,
Any questions? I would be happy to answer all.
Sir, could you please explain
Go on.
Hello,
Yes, Mr. Samanayak.
sir. Good
sir?
good afternoon, sir. Really happy, sir. By very interested, very burning issues. to every the common people how to develop the based on the evidences. They very well explained, sir. But now the nowadays the revenue department provided the white card and yellow card, the below poverty level or above poverty level. The nowadays they have introducing the Aadhaar card, the how to identify above level and below level. I'm sorry, PPL and APL.
Okay. And your question is, sir? What is your question, sir?
Sir, above poverty level and below poverty level, how can identify the
No, that
Aadhaar card?
classification is permissible.
Yes, sir. How can there is no
I'll tell
qualification?
you. I'll tell
Long.
you. I'll tell you. I'll tell you how it's permissible.
Okay, sir.
See, when you're classifying now, who is eligible to say ration or subsidized services? You are doing a social function of a democracy. I mean, in a democracy, you are uplifting the poor. That is directly a directive principle of state policy. And directive principle of state policy is used to be guided to formulating and making laws. So this classification is permissible, completely 100% permissible, because you identify poor people and you give them services. You give services to them. So it is permissible, in my view.
Sir, I am asking, how can identify, sir? Now the white card, yellow card, you understood or not, sir? The ration
Yes.
nowadays, Dr. Y.S. Jagan Mohan Reddy introducing their logo and their cards.
Oh, okay.
There is no
That's
differences.
impermissible.
Yes, sir. Yes, sir.
That's your right. Then that is not valid.
Who are non-employee? Who are the employee? Who are the non-employee? Also not identified those numbers. Hello.
I'm sorry, I didn't get it, sir. I didn't understand your question. I'm so sorry.
Who are the employee? Who are the non-employee? Above poverty level and below poverty level, those the white card, yellow card. They mentioned the previous government. Rich people, poor people. In the ration provisions also differences. In the above poverty level is different. Below poverty level is different. They are providing in dealers.
I think that is permissible, but if some political leader has a stamp of their political party or the emblem or their symbol of their political party on the Aadhaar card, that's absolutely impermissible. That's a violation of the Representation of People's Act also.
Sir, what he meant was that the local rules, and especially in the reference with the Andhra, there are the provisions of this ration cards to various grounds of people, various levels of people, like based on their income and based on their PAN card and Aadhaar card. So there are pink cards and white cards issued for ration facilities, vagera. So he's
Oh,
saying that whether the right to privacy is being violated with those things that the government are doing.
no, it's not.
It's not necessary.
It's
Their
not
income.
because when can a person assert privacy? When the person is alive, when the person has food to eat and stomach to fill. That's how a person can assert the right to privacy.
And their government intention is correct, that they want to help
Correct.
only day.
But it can also be questionable.
Sir, again, it's a debatable topic. If we go with the government policies, it would be a debatable
Always
topic.
debatable because always it's balancing competing interests again, as I said.
And various perspectives from each corner. The one who is beneficiary would be obviously satisfied, and the other would be not.
True, absolutely.
Any
Any
other
other
question?
questions? I'll be happy to take it.
Sir, is the same principle being there in the International Court of Justice also?
It is there in the United Nations Charter of Human Rights in the ECHR, which is the legislation for the entire UK. It's a principle of the European Court of Human Rights. It is internationally recognized. But your privacy, what one topic I couldn't touch upon is your dress code and the privacy. The recent hijab judgment of the Supreme Court. That again is a non-judgment because it's a split opinion. So for the time being, the Karnataka High Court's judgment holds the ground only for Karnataka because no other High Court has decided it.
And even the Supreme Court hasn't taken up the matter yet.
Correct. Absolutely. You're absolutely right, ma'am. Now, some countries say that a right to dress is not fundamental to your privacy. Some countries say it is. France has banned burqas. France has banned uh, veils, headscarves, hijabs. They banned it. They say that it is contrary to their fundamental principle of Rousseau, which Rousseau propounded of liberty, equality, and fraternity. These overt symbols of discrimination go against fraternity. That's what they say.
Then the other principles like protection of sovereignties, they all go with the hands in the privacy, no sir. Federalism, sovereignty, everything, republic, democratic, all those things go with the hands of privacy.
Only if a country is a sovereign democratic republic can a right such as privacy be invoked or even asserted. It's a prerequisite. Tomorrow there's a dictatorship. Privacy रहेगा?
The present China, North Korea.
North Korea, present China, Russia.
Thank you, sir. Sir, now I would like to request Srishti to conclude. Srishti, any other questions or any other things from that you want to put in?
Yes, sir. I want to, sir, could you please explain again the right to be forgotten clause?
Yes. The right to be forgotten is a right of a person who has either been acquitted in a criminal case or has won a civil case or got mostly has got negative publicity as a consequence of his actions. Say I am a bank defaulter, okay? I take away 10,000 crore rupees and I rush to England. Okay? Tomorrow I am deported back to India and I face prosecution. I win the prosecution and I pay the loan of 10,000 crores and the interest on the loan. Then I can tell the court that all the negative publicity that I received during this period to this period should be removed from the public memory. Anyway, the public memory is very short. So, but still, it's wonderful to have such a right because internet has everything. You write a research paper today, it will be on the internet for 100 years. You write your name today, you take a photo of me and put it up there. That photo will be there for times to come. Hamesha rahega. Say if I'm in a private moment, if I'm caught, say, intimately kissing my girlfriend or my wife or my so and so, if I'm kissing somebody and it's that photograph is taken without my consent, uploaded on the internet, I can say, please remove it from the internet. I can write to Google that I have a right to be forgotten. This was taken without my consent.
So we could also use these clause in cases of defamation too, right?
Absolutely, absolutely correct. You have understood it.
Thank you, sir.
Any other questions?
Any other questions from any of the participants or so? Okay. Sir, I would like to conclude the webinar now. I'm really glad to conclude this. We, I would wholeheartedly thank you for giving this such a wonderful information. It's like more than an information from one man. It's like a discussion, a seminar, a conference, and it's like we knew like from basics to the interpretation level. So thank you very much, sir. I would like to thank you wholeheartedly from bottom of my heart.
Thank you so
I,
much.
on behalf of the association as well, we are very sorry that the organizer Pavan Kalyan isn't here, but he hope so. We'll get you back soon in through a call, sir. We are very sorry for that, but I would like to thank all the participants, my co-host Risti also. Thank you so much for everyone for making this webinar, our 13th webinar within no time. We started this organization only a month back, and this is our 13th webinar with directly Supreme Court Advocate. So really, thank you, sir. Thank you so much for making this webinar success. I would like
Most
to extend your support more in the future also, sir. Thank you.
absolutely.
Thank you so much. Thank you so much for the participants also. Thank you. Thank you. Thank you very much.